session. I think we have 1, 2, 3, 4, 5, 6 of us here. That's enough to get a quorum going. And I'm going to call first bill will be Senate Bill 332, sponsored by my good friend Senator Stone, Jesse Stone.
All right. I'm sorry. Which
No
bill?
problem. 332. Tell the person with you that we're in session.
I'm not good at that multitasking.
Nor am I.
This bill does something very simple. It raises the maximum contempt fine in magistrate court to $500. This brings it in line with courts of comparable stature. Municipal courts are at 500, so are probate courts. It's still half the level of the upper level courts, state and superior. It's overdue because of time. We had testimony that the fine level had not been adjusted in approximately 20 years.
Nor has our salary been.
No, actually, and of course they're two separate things.
Okay.
I'll be happy to try to answer.
All right, so it goes from 200 to 500.
Right.
Do we have any questions from members of the committee of the presenter?
How long has it been 200?
We'll push your button, and I'll recognize you. Yes, sir. Mr. Rutledge.
Thank you, Mr. Chairman. How long has it been 200?
I think
I'm Judge Alan Harvey, Judge of the DeKalb County Magistrate Court.
Pull your mic over there, Alan.
Immediate past president of the
We got
Council
millions of
Magistrate
people
Court
watching us
judges.
all over the
Oh.
world.
I get my makeup. I've been a judge in the magistrate court for almost 29 years, and it's been, as far as I know, the entire 30-year existence of the magistrate court system.
All right. Anything further? We have nothing further. You had some suggestion I want you to talk about. I don't know if you talked to
Well, I haven't had a
Stone.
chance, and I want to.
I mean, what y'all were talking about when I started the session before you had a chance to really discuss it. He was looking at, I think, we also say imprisonment not to exceed 10 days or both. And I think what you're telling me, Judge Harvey, is the other contempt provisions provide for up to 20 days.
And there's other courts, and again, I haven't had a chance to discuss with Senator Stone. We appreciate him putting this bill, and I don't want to put him in a spot here. But the probate court and other courts have 20 days. I think it's just a matter of consistency across the court lines. I mean, we don't have. Again, we appreciate what the Senate has passed and what we have here today. But that was just a.
I leave that to the committee. The time value of
that's what I'm thinking about. The one thing it would do is potentially hold up our. If we pass it with a change in it, it's amended, then it goes back to the Senate to be approved or disagree. Then it gets disagreed, then you never know where it stops.
No, we don't want to. We do not want to see that. We're happy.
I will say this: in the superior courts, we had a similar bill that raised their contempt a year or two ago, and we started out with a recommendation from the courts to change the incarceration period. But I think the consensus finally was that the time value of days spent in jail is still
I'll
the
say,
same.
how many times do you even send anybody to 10 days for contempt in any court?
But I understand the consistency issue, and maybe at an appropriate time that can be addressed.
All right. Thank you. Is there anyone else who wishes to speak on Senate Bill 332? If not, we'll close off further public comment. The bill is now in the breast of the committee. Do we have any discussion? If there's no discussion, the chair will entertain motions. We have motion due pass and seconded. Any further discussion on the motion? Are there any amendments? No amendments. We'll call the main question, which is a recommendation due pass Senate Bill 332. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. You have another bill. You're now before us with Senate Bill 341. Senator Stone.
Yes, Mr. Chairman.
Oh, I'm sorry. Let me ask you. you have who to carry your first bill? Do you know?
Representative Jacobs over there.
Jacobs, all right, thank you. Sorry. Go ahead, 341.
All right. The what this bill does is deals with probate courts, and it removes a population provision that had been in the law, and the law basically allowed for it in certain population jurisdictions probate judges to delegate uncontested matters to either persons in the office who were admitted to the bar for at least 3 years, or to clerks who had been in the office for 5 years. This is something that has worked well in the larger jurisdictions. The smaller jurisdictions would like it now. It will help provide more accessibility to services of the court on ministerial matters in the rural areas in particular, when the judge is out. And the Probate Judges Council has requested this.
All right, and we don't have the language of what is currently
There
the
was a
old
change.
section C. I think Ms. Travis, you have it there.
Yes, when you're repealing, you have to reenact. So C1 and 2 are the same as what's there now. The language that's not there will not be there if this bill were to pass. This subsection shall apply to each county of this state having a population of 90,000 or more persons according to the United States Decennial Census of 2010 or any future census.
Yeah. That population, I think, ties into what we have as far as those where you have requirements of a probate judge also being a member of the bar. Is that right?
That language is actually in your bill at line 19. I'm sorry.
The $90,000. Excuse me, the 90,000 people.
Okay.
Is the same standard that has to be a member of the bar to be a probate.
Okay, so now we're doing it without the judge, but saying a chief clerk or designated clerk who has been a member of the state bar for at least 3 years.
Right. This doesn't deal with the judge. This is the clerk.
All right. Interesting. Anything further for you, Senator Stones? If we have questions, I believe we have one from Mr. Powell.
Thank you, Mr. Chairman. Say, for instance, I was doing an uncontested probate of a will, and I went into the court and the judge is not there and the clerk is there, and the clerk signs documents authorizing or admitting the will to probate, but the clerk is not a member of the bar and who has not been there for 5 years. I mean, are my documents now void or subject to challenge, or am I under a duty as a participant in the court to find out what the authority of this clerk, because your typical person coming into court is not going to ask that question, and if somebody says, well, gosh, clerks over in Daugherty County signed documents, or clerks in Colquitt County, and so they just assume that they might have that authority without reading the law, where does that put us?
That's a question we haven't considered, but I would think it would require the proper executions. I mean, it could be challenged, I would think, as maybe ultra vires act.
What would be an example? I'm sorry, you threw on your
Yes,
part?
sir. Yes, sir.
Senator, what would be an example of your aware in the probate courts where we would have this type of action being taken by a clerk?
Well, the biggest example is, as Representative Powell said, is the probating an uncontested will. But there are other matters that come before probate courts that are uncontested as well, and a lot.
I don't know if a will would fall in that category. The reason I
Really?
suggest that is that you have to have a court sign the order of probate. And then if you're going to use certified copies, that has to be attested to by the clerk. So I don't think the clerk could do both roles. Can't sign the order as well as attest that I've got the authority. Because what you rely on is that attestation that says this person has the authority to actually execute this document. And that's why I say I don't think my thinking is, Mr. Powell, that you don't? How would you have, we'll talk about it during our discussion, but that's just something I wondered if that, I could see maybe issuing gun permits, things of that nature, which would be somewhat ministerial in their approach. Wedding licenses, as ministerial in their approach. But an order of the court to probate the will is just that, it's an order of the court.
I think what will probably happen, this passes, the probate judge's council will probably come out with guidelines to help administer this around the state. But I see the issue, potential issue of a signed order that has to be attested to. That would have to be worked through.
We have another question, Mr. Fleming.
Mr. Chairman, I was only going to add that I think in subcommittee somebody mentioned they thought a temporary guardianship could be ended, would not be contested. That would be a possibility of something the clerk could do.
All right. Any further questions of the presenter? Thank you. Does anyone wish to speak on behalf of Senate Bill 341? If not, we'll close off further public input, and the bill is now in the breast of the committee. Any discussion among members? And I guess we can talk about it a little bit. Yes, sir.
I just want to follow up. I'm going to vote for your bill, and if the chairman will let me, I'll make the motion. But I wish the probate judges would look into this and maybe even consider saying that in order to be a chief deputy, that somebody has to be a member of the bar for 3 years and 5 years, or 5 years as a clerk, and then just say that only the chief clerk can do this. I think that would give us an additional level of security there. But just ask for them to look at it, or put in there that that maybe it would not void the documents. But I'm just concerned about somebody challenging something later on.
So am I. But I believe the probate judge's council will probably work through guidelines for guidance around the state on that.
Okay. That's all, Mr. Chairman.
Thank you. Mr. Fleming.
I was just going to say, to Chairman Powell's concern, I think it's a very good question, but realizing that we already do this in Georgia right now, if you're a county above 90,000 people, which has got to be, I don't know how many, a dozen or 20 or more. So there is some experience out there with making this work, and I guess if we'd had problems, we'd have heard about it by now. We're just fixing to extend this to the rest of the counties.
That's right.
I'd say all the counties I think I practice in are above 90,000, and I've never seen a clerk sign what constitutes a need for an order,
right?
Which is an order to say probate the will. I think it has to be a judge saying that situation, because again, I go back, someone has to then attest to the authority and it being a true order of the court, and that's where you couldn't have the clerk attesting their own authority in that role. But let them work that through. Hopefully they'll come with a good answer. Thank you. No further discussion among committee. The chair will entertain a motion. We have a motion by Mr. Powell to do pass, and seconded by Mr. Fleming. Any further discussion on the motion? If there's none, are there any amendments? No amendments proposed. The chair will call the main question, which is due pass to Senate Bill 341. All in favor signify by saying aye. Aye. Opposed, like sign. Fine. Mr. Stone, is that all your bills today?
That's all I have for the day, and I appreciate.
Please report back to your chair rules how kindly you were treated.
I've never been treated unkind over here, so I will definitely do that.
Good to see you, always. Oh, you got a sponsor too on that second bill.
I believe
Mr. Fleming will be the floor sponsor. Thank you. Next we have Senator Albers.
Thank you, Mr. Chairman.
And you're here on 2 items also, I believe.
I am. This is the 2-for-1 day, right?
What a deal. What a deal. We'll first look at Senate Bill 325 by Senator Albers.
Thank you. With your permission, Mr. Chairman, I'd like to ask Mr. J. Florence to come join me here from the Insurance and Fire Safety Commissioner's office.
You can get the other chair. Pull that one over a little bit. There you are. Happy to have you identify yourself and who you're with for us.
Yes, Mr. Chairman. My name is Jay Florence, and I'm the Assistant Commissioner at the Department of Insurance, or the Office of Insurance and Safety Fire Commissioner.
All right. Thank you.
Thank you, Mr. Chairman, members of the committee. I bring before you Senate Bill 325, which was requested by our Insurance and Fire Safety Commissioner. And it's broken down into 3 different parts here, and we vetted this through subcommittee yesterday as well. Let me give you an overview. The first part is it gives the Fire Safety Commissioner the authority to enforce the licensing requirements, specifically where it pertains to sprinklers and extinguishers. The second thing it does is it gives business owners a chance to remedy violations before they're fined. So if there is a problem, they will get a written notice provided to them. They'll have a timetable to fix it before incurring any fines. And last but not least, it permits the Commissioner to refuse an application if an applicant has been dishonest, perhaps saying they were qualified to do work they weren't for some time. And we want to make sure that whomever are doing these jobs of installing either sprinklers or extinguishers are doing so that are certified for all the reasons we can imagine. We don't want there to be a problem and them not function properly, as well as we want to assure that if there is an issue and insurance is in play, that we dotted all our I's and crossed our T's. I view this as a great bill for our insurance commissioner, for our fire marshals, and ultimately for those who own our businesses. And I will yield for questions.
Questions of Senator Albers? And would you have something you'd like to add to it?
Mr. Chairman, I think you did an excellent job presenting. I'm happy to help answer any questions should the committee have any.
Any questions? One thing you brought up, I'll ask a question, is maybe this goes to Ms. Florence. All times when you have a fire retardant system, sprinkler system being put in, that does require local permitting, does it not?
Yeah, it will require a permit, and then they will have the fire marshal will come inspect that when it is done.
So if you did it without a permit, you violated local ordinance and state law?
And this is specifically related to the contractor who is installing.
Correct. And to say if you do it without having a permit, is it only permitted at local level, or do something needs to be issued by the state level?
So yes, the Safety Fire Commissioner, the State Fire Marshal's office licenses the sprinkler and fire extinguisher contractors.
You ever find people doing it without a license?
Yes, sir, which is one of the reasons that we are bringing this bill.
Okay, good deal. Other questions, if any? If not, we thank you, Senator. Is there anyone else who would like to address the committee on Senate Bill 325? If not, we will close off further public comment. The bill is now in the breast of the committee. Is there any discussion among members of the committee? If not, the chair will entertain a motion. Motion do pass. It's been seconded. And is there any discussion on the motion or any amendments to be offered? There being none, we'll consider the main question, which is do pass Senate Bill 325. All in favor signify by saying aye.
Aye.
Like sign. No. Passes. Thank you, sir.
Thank you, Mr. Chairman. And Representative Harrell will be carrying that bill in the House.
Thank you, Mr. Chairman.
You're so welcome. I would say in memory, I don't recall us ever doing 3 bills that didn't have substitutes.
I'd like to go 4 for 4, Mr. Chairman, if we can.
This next one does a substitute. It is a substitute.
Oh, all right.
We're looking now at a substitute to Senate Bill 386, LC 296018S in your folder. Senator Albers.
Thank you again, Mr. Chairman, members of the committee. Give you a little background on this bill. Several months ago, a constituent of actually both of ours contacted me because he had
called me.
I don't know. Probably alphabetical. He searched his name, Googled it online, and clicked on the Fulton County Court's website to find his name, his address, his phone number, and his Social Security number and his date of birth, referencing our old driver's license information. As we remember, that used to be our Social Security numbers. He called myself. He also called Dale Russell from the Fox 5 I team. When he called me, I was concerned. I was even more concerned when I Googled my own name and found the same thing. And just for the record, that accident was not my fault.
Heard that before.
I'm retaining counsel now. Yes, when I got hit from behind. Mr. Chairman, we work with Fulton County, and thankfully, and for maybe the first time, they worked very quickly to fix that. And we, from that point, decided to dig into that a little deeper and realized what we thought was a small problem was a very broad issue. So I really want to commend all the folks that came together to help out in this bill. Certainly Chairman Jacobs here on your committee, who has a companion bill. We had Justice Namias from the Supreme Court. We had Justice Tom Campbell from Fulton Court. We had the clerks of the court. We had everyone together to figure out how can we be sure we are protecting private and confidential information that are going in the court documents, knowing that the clerk can't go through hundreds of years of warehouses of documents either. It has to be caught as it's coming in, and putting the onus on those that were entering those filings. And specifically, you will see in this bill things such as the last 4 digits of Social Security number could remain, but we can't have the whole Social Security number. The last 2 years of birth, not the entire birth date. And as you can imagine, banking documents and account numbers, all those things we're concerned about, knowing that identity theft is at an all-time high and continues to be kind of our modern-day form of the bank robbery, will continue to be a concern. This bill seeks to address those, and I think we've crafted something that most everyone is comfortable with throughout that process. So with that, I would yield to any questions from the committee.
Any questions? I do see a light. And that would be you, Mr. Weldon. Thank you.
Thank you, Mr. Chairman. I remember working on this bill in subcommittee, and then I was back home working on some issues in a domestic relations matter. And in the domestic relations financial affidavits required by the statute, has that, and I don't remember if this addresses that statute that sets forth the form of the, is it statute or is that in uniform? Okay, so it won't be in here. It has? Okay. That answers the question. Thank you.
Thank you.
Any further questions? I believe you have yours, Mr. Jacobs.
Yeah, I just wanted to note for the members of the full committee that the bill you have in front of you is substantially similar to House Bill 977. We made 2 changes to the bill. One was to repeat the new code section that we were putting in the Civil Practice Act in the magistrate court code, because the magistrate judges didn't want to have a cross-reference, so we decided to just replicate it in the magistrate code. And then the other was, the question came up, well, how do we address garnishment cases when it is actually useful to have a summons of garnishment served with the financial account number or Social Security number on it, on the garnishee? The approach the subcommittee decided to take with that was that we ought to still preserve the policy consideration of redacting that information for the public record, but that a copy of the summons of garnishment should be served on the garnishee with the full number on it. We gave Ms. Travis artistic license to effectuate that in the bill. I do have a couple of places I'd like to tighten it up by amendment, but she did an outstanding job on that. I did not realize, though, that when we gave Ms. Travis artistic license, we would more than double the length of the bill. But that's because we had to go into the garnishment code and fix a few things in there. So that being said, Mr. Chairman, it's pretty much the same bill as 977 with a couple of tweaks.
Thank you. Mr. Rutledge.
Thank you, Mr. Chairman. I saw the news report, and it's kind of startling too. How many folks do you think have information out there like this, and who's going to take all this information out? Who's going to sit in the courthouse and go through, and how do you do all that?
Great question, Representative. That was my original intent when I first looked at this issue. Thought, well, we can just fix it all. Very quickly, I was educated by our clerks and our justices that would be an impossible feat, because it probably affects hundreds of thousands of people in our state. So all we can really do is moving forward.
All right. Anything further as far as members of the committee for questions of the presenter? If not, thank you, Senator. Is anyone else who wishes to speak to the committee on Senate Bill 386? If there is none, we will close off further comment from the public. Yes, sir, Mr. Weldon.
Thank you, Mr. Chairman. Senator Albers, have you been able to take a look at the revisions that subcommittee made?
I did see those revisions, yes.
And you're those are friendly amendments?
Very much so. Thank you, sir.
Thank you.
All right. Thank you, Senator Albers. We will close off further comment from the audience, and the bill is now in the breast of the committee. We're considering Senate Bill 386. Do we have any discussion among members of the committee? If not, Chair will entertain a motion. Do pass. Seconded. Do we have any amendments, Mr. Jacobs?
I do, Mr. Chairman.
State your amendment.
On the new garnishment language that's put in the two main code sections, what I would propose to do is and then I'll explain the amendments. On line 28, and this will all be part of the same amendment. On line 28 and line 104.
Let's do it one at a time.
Okay.
Let's talk about your line 28 amendment first.
Well, because I'll tell you what, I'll split these into two amendments.
Explain them first, then you can all.
Certainly, I'll split them into two amendments. The one concern I have is that, what we're saying, a copy of the summons of garnishment, and I don't think that makes clear that, that then brings up the question: am I serving the same summons of garnishment but a different version of it, or am I serving the redacted summons of garnishment with a copy that is unredacted? And so the amendment's actually a very simple one on lines 28 and 104 of the bill to strike A in front of the word copy and make it the. So it's just one summons of garnishment with an unredacted number served on the garnishee.
All right, offer your first one as being to line 28.
Well, those two subsections are exactly the same.
I realize they are.
Okay, sorry.
Just offer them as separate items because they've got different pages and different sections.
Certainly. Line 28, strike A, replace it with the in front of copy.
All right, we have a motion to amend by Jacob, seconded by Mr. Weldon. Any discussion on the amendment? All in favor of the amendment signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Do you have further amendments?
The next amendment would be on lines 29 and 30, because I think we actually want the defendant to see a redacted version so that they can be sure that the information has been redacted. Would be to strike, place a period on line 29 after the word garnishee, and strike the balance of lines 29 and 30.
May I inquire? So normal law requires that there be a service of the sums of garnishment on the defendant also. How does that part of the law become affected?
That would not become affected.
So that's why we're striking it. There's also a provision under this garnishment law that addresses the service of a defendant's notice by mail, correct?
That's right. If we want to, that's right, by certified mail. The other.
So we're not changing what's really required for that type of service. This is just redundant for no reason to have it there.
Correct. But there's another way we could do this that would be clearer now that you asked the question. So I'll withdraw that amendment.
All right. Ms. Travis?
The summons and garnishment is served the same way as we change it to reflect the same as now 11.4.
Right.
Yeah.
This on the garnishee.
On the defendant, I'm saying. On the garnishee, you're correct.
Correct.
It's not on the defendant.
When it's served on a defendant, it's by certified mail within a certain period of time after the case is filed.
That's right.
So actually, I'll withdraw that amendment, and what I would propose to do on line 29, on line 29, strike A in front of copy, strike may and change it to shall, and strike on line 30 and unredacted and change it to redacted.
Well,
so it would read, and the copy of the summons of garnishment served on the defendant shall include such information in, or we'll make it in redacted format, period. And the copy of the summons of garnishment served on the defendant shall include such information in redacted format.
Does everyone understand the amendment? We have a question from Ms. Evans.
Thank you, Mr. Chairman. I think because the account information that we're talking about here is going to be or not be the defendant's, I think the defendant should be able to see it in redacted and unredacted form.
Well, now you're talking about two different documents being required, I think, to be served. May I insert? I think your first proposed amendment would be sufficient. This is only talking about under the section we're dealing in of 911.7.1, this area that you've added for garnishment as to the redaction of information on the court records. The fact of what is served on a defendant under the statutes dealing with garnishment doesn't need to be touched.
All right. Then
I think you're all right. I just wanted to clarify what we're talking about here.
Then, Mr. Chairman, I'll withdraw that amendment that I just stated and restate the original amendment, which is to insert the period after the word garnishee and strike the balance of lines 29 and 30.
We only discuss within this provision of law what is being done as far as service on the defendant. That's covered under the garnishment statute. Correct?
That's correct.
All right. So the motion to amend is to place on line 29 a period after garnishee and strike the remainder of the sentence. Does everyone understand the amendment? Is there any discussion further on the amendment? Ms. Evans.
Thank you, Mr. Chairman. Is the form, whether redacted or unredacted, that's going to go to the defendant somewhere else in here? Because I think we've got to make sure that the defendant's going to have a right to see the unredacted information so that they can contest or otherwise have full information to be able to talk to their bank about what accounts may or may not be subject to the garnishment. Because otherwise I think we might be leaving them with just a redacted copy.
You're right. And I think the fact is the law under garnishment requires that notice going to them to be the actual information you're talking about.
I think it requires it to be whatever's filed with the court, and if what's filed with the court is redacted, then I don't think they're going to otherwise have a right to the unredacted. Unless they go to the bank and get it.
Mr. Chairman.
Let me read through this just a second.
Page 5.
Okay. Mr. Powell.
I understand the concern, but I really do not think that it makes a whole lot of difference what the defendant gets. If it ain't him, he's going to file a traverse, and they're going to have to prove that it's him anyway. And so whether he gets the redacted or unredacted, he knows that an account has been garnished. And if it's not him that is the defendant or the correct person or the correct account, he's going to file a traverse. He knows it's not him.
Hold on. Let's have a discussion as a committee. Let's have a discussion as a committee. Any further discussion with regards to the proposed amendment? Jacob.
Just to Chairman Powell's point, I mean, the person is going to know that I have a bank account at that bank, or I don't have a bank, or this does not appear to be me. I mean, I do think it is adequately addressed simply by serving the version of the summons of garnishment that is redacted that is filed with the court, and more to the point, I think you want to make sure that that is the version that is served on the defendant so that they can be sure that their information has been redacted in the version that's filed with the court. And it's going to have the last 4 digits. I mean, I think they get adequate information to know whether they should traverse or not.
Any comments? Let's push your button, Ms. Evans, if you want to ask something or comment.
That may very well be true. It just seems like, why would we give more information to the bank about the defendant's personal information than we give to the defendant himself? It just seems like he would want to be able to confirm it in both places, or she, or it.
All right. Further comments? There being none, we will talk about the amendment. The amendment, as it again stands, is to place a period after garnishee and then strike the remainder of the sentence. Is there any further discussion? There being none, the chair will call the question to amend the Jacobs Amendment number 2. All in favor signify by saying aye. Aye. Opposed, like sign. The ayes carry. Amendment passes.
The next amendment, Mr. Chairman?
Yes. Excuse me, go ahead.
Would be to strike the on line 104 in front of copy, and I'm sorry, A in front of copy on line 104 and replace it with the.
All right. That is the Jacobs' third amendment. Any discussion on the? Is there a second to the amendment? Second. We have a second. Any discussion on the amendment? If not, the chair will call the Jacobs' third amendment. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries.
Next amendment, Mr. Chairman, would be to insert a period on line 104 and strike the after garnishee, and then strike the balance of lines 104, 105, and 106.
All right. Everyone understand the amendment? We have a second to it. It's been seconded. Any discussion on the amendment? If not, the chair will call the question of Jacobs Amendment number 3. All in favor signify by saying aye. Aye. Opposed, like sign. Amendment carries. Any further amendments?
Yes, the last set of amendments is in reading this code section that we've amended in the garnishment code. I am concerned there is on lines 145 and 146 a standard to the extent reasonably that you have to disclose this information to the garnishee to the extent reasonably available to the plaintiff. Then we mandated on lines 157 and 158 and 163 and 164, and then we have a different standard on line 142, and that is known instead of reasonably available. So the first amendment would be to just line all of this up with the same standard. The first of 3 amendments to make this all happen would be on line 142, strike the word known and make it reasonably available. Well, you already have.
I'm having concern about where we're going with all the amendments in this particular provision, and I'm really fretful about if we're doing something that may cause disruption in our garnishment law. I'm going to suggest I'm going to refer this back to your subcommittee. You get it done and have it prepared to be presented to the full committee at the next meeting. All right,
that sounds good, and we'll hear this for folks in the audience who may be interested in this bill. We'll hear this bill today at 4 p.m.
Okay, let's do that. I don't like doing it on the fly too much.
Thank you, Mr. Chairman.
You're welcome. I'm sorry we couldn't get everything out, but caution's the better part of valor here.
Thank
I want to recognize Judge Arch McGarity, Flint Circuit, just south of here. Former president of the Superior Court Council of Judges. Glad to have you with us today, Your Honor. And we already saw Alan Harvey earlier, my former law partner from years back. He's just a little boy. Any other judges in the audience? We had somebody here earlier. I forget.
Judge Crawford was here, but he had
Matt Crawford. Okay. Anything else to come before the committee? Monday, is it Monday? What day is it, our dinner? Monday evening we have the state bar entertaining us for dinner. I want everybody to keep that on your calendar. Okay. Are you on his subcommittee? Good. That's all right. Just get that worked out for us so we don't have the long problems discussion. Please do that. I need some help, I see.